for this week's class, I decided to do Chapter 9 on intellectual property for our case study. Um, the case study I chose to do today was 9.2, the Dallas Cowboys Cheerleaders Incorporated versus the Pussycat Cinema Ltd. And basically this is an appeals from the orders of the United States District Court for the Southern District of New York. And on March 14th, this court granted defendant's motion to stay the injunction and ordered an expedited appeal. This is Dallas Cowboy Cheerleaders are the plaintiff, and the Debbie Doos Dallas is the cinema or the movie that was created off of the Dallas Cowboy Cheerleaders that the Pussycat Cinema put out there, and that is the defendant today. So the basic points of this case is that the plaintiff is basically saying that they had a trademark infringement action by the Dallas Cowboy Cheerleaders. And basically, just to go into a little background, the Dallas Cowboy Cheerleaders usually employ about 36 women who perform dance and cheerleading routines at Dallas Cowboys football games. They've appeared on television programs, make commercial appearances at public events, sporting goods shows, and shopping center openings. But the biggest thing is that on their trademark is they have the Dallas Cowboy Cheerleaders uniform. And they have national exposure by the Dallas Cowboy Cheerleaders. And they have received this image through the news and entertainment media all across the nation. So therefore, in this basic and through the facts, for the plaintiff, the women are clad in the plaintiff's distinctive uniform. And basically that uniform that is very familiar to everyone around the nation, with the white vinyl boots, the white shorts, a white belt decorated with blue stars, a blue bolero blouse, and a white vest decorated with 3 blue stars on each side of the front and a white fringe around the bottom. Everybody knows that that is the Dallas Cowboy Cheerleaders' well-known uniform. It's what they wear to every national event that they do, every football game, etc. And basically, they are saying that this asserts a trademark in its uniform, and it was diluted in the trademark in advertising and exposition of this Debbie Doos Dallas. So now we'll go into what this Debbie Doos Dallas is and why this case came about. So this is a cinema, the Pussycat Cinema, is a New York corporation that owns a movie theater in New York City. In November of '78, they began to show Debbie Doos Dallas, which is a gross and revolting sex film whose plot involves a cheerleader at a fictional high school, and her name was Debbie, who has been selected to become the Texas Cowgirl. In order to send money, in order to raise money to send Debbie and eventually the entire squad to Dallas, the cheerleaders performed sexual services for a fee. And the movie consists of large, long scenes of graphic scenes depicting the sexual escapades of the actors. But the reason why this is became such a trademark infringement is because the uniform that Debbie is wearing is strikingly similar to the uniform that the Dallas Cowboy Cheerleaders wear themselves. Approximately 12 minutes of the film footage engages in various sex acts while clad or partially clad in the uniform. So they are the posters that also depict Debbie are infringing uniform and containing such captions as starring ex-Dallas Cowboys cheerleader Bambi Woods, and you'll do more than cheer for this ex-Dallas cheerleader. So there are the reasons why the plaintiff is calling an infringement on trademark of the uniform, because that is their property and they feel like that is an infringement. So basically they brought this action alleging trademark infringement under the Lanham Act of unfair competition and dilution of trademark in violation of the New York General Business Law. February of 79, they found that the plaintiff has succeeded in proving by overwhelming evidence the merits of each one of its contentions. The defendant challenged the validity of all three claims. So, with that being said, they had a preliminary issue raised by the defendants, basically saying that they raised an issue that it had a valid trademark in its cheerleading uniform. They argued that the uniform is purely a functional item necessary for the performance of cheerleading routines and that is therefore not capable of becoming a trademark. And so, as they were going through, and with all these quarrels of the defendant's assertion of its being purely functional, they did not agree that all of the characteristics of the plaintiff's uniform serve only a functional purpose, or that because an item is in part incidentally functional, it is necessary precluder from being designated as a trademark. So, while it is fitted to allow free movement while performing cheerleading routines, it claims that the trademark in the particular combination of colors and collaboration of decorations that distinguish the plaintiff's uniform from those of other squads. And so the design may become a trademark even if the item itself is functional. So basically, they're saying that the combination of the white boots, the white shorts, the blue blouse, and the white star-studded vest and belt is an arbitrary design that makes the otherwise functional uniform trademarkable. So, however, while going through this, they must determine whether the depiction of the uniform in Debbie Does Dallas violates that trademark. The district court compared the uniform from the movie and to the Dallas Cowboy Cheerleaders, and the marquee closely resembled plaintiff's uniform and that the public was likely to identify it as the plaintiff's uniform. So therefore, the district court was correct in saying that they were to pick out, if they were to watch that movie or scene, they would know that that is the Dallas Cowboy Cheerleaders uniform. So therefore, under the Lanham Act, the public is unlikely to be confused within the meaning of that Lanham Act, therefore making the uniform a trademarkable functional uniform. So, to counter that, Debbie Does Dallas unquestionably brings to mind the Dallas Cowboy Cheerleaders. It's hard to believe that anyone who had seen defendant's sexually depraved film could even therefore disassociate it from plaintiff's cheerleaders. The association results in confusion that had a tendency to impinge, or basically the plaintiff's services, and injure plaintiff's business reputation. So, moral of the story, the plaintiff's trademark is in the nature of a property right, and as such, it need not yield to the exercise of First Amendment rights under circumstances where adequate alternative venues of communication exist. So basically, under the government, but a private plaintiff's attempt to protect its property rights. So all in all, the moral of the story was that it was a trademark, but this is the property of the Dallas Cowboy Cheerleaders. They are trademarking that specific property to protect those rights. So in the end, the plaintiff has established a probability of success at trial, and the confusion engendered by defendant's move will result in irreparable harm to plaintiff where defendants not enjoined from its distribution and exhibition. So accordingly, through this case, they affirmed that the order of the district court to rule in favor of the plaintiff that they are in violation of their trademark held true, and I believe that they made the correct judgment because depicting a Dallas Cowboy Cheerleaders in a rated X movie is something to be very alarmed of and to protect your property rights as a Dallas Cowboy Cheerleaders. So therefore, I would also rule in favor of the district court to rule in favor of the plaintiff, which is the Dallas Cowboy Cheerleaders, against Pussycat cinema involving the altered depiction of the Dallas Cowboy cheerleaders uniform. Thank you.